A brief announcement. We are about to begin with our inaugural session shortly. Thank you. My Lord Shri Justice Abhay S. Oak, Honorable Judge Supreme Court of India, My Lord Shri Justice Suresh Kumar Kaid, Honorable Chief Justice High Court of Madhya Pradesh and Patron Governing Council, Madhya Pradesh State Judicial Academy, My Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Judge High Court of Madhya Pradesh and Chairman Governing Council, Madhya Pradesh State Judicial Academy, Honorable Judges High Court of Madhya Pradesh, present here and connected online, Shri Dharminder Singh, Registrar General and Officers of the Registry, Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy and Officers of the Academy, Shri Pradeep Mittal, Member Secretary, Madhya Pradesh State Legal Services Authority and Officers of MP Salsa, participating Principal District and Sessions Judges, Judges from District Court Jabalpur, Judges from the District Judiciary who have joined us virtually, ladies and gentlemen, warm greetings to everyone. Namaste. I warmly welcome our distinguished guests, esteemed participants, and all attendees to the inaugural session of the two-day conference of Principal District and Sessions Judges. We are honored to have distinguished guests amongst us today. Hence, commencing the program, I would like to begin with the felicitation of our honorable guest. I request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, Jabalpur, to welcome our chief guest, my Lord, Honorable Shri Justice Abhay S. Oak, Judge Supreme Court of India, by presenting his Lordship a planter. Thank you, sir. I now request Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, to please welcome my Lord Shri Justice Suresh Kumar Kaid, Honorable Chief Justice, High Court of Madhya Pradesh, by presenting a planter. Thank you, sir. I now request Shri Pradeep Mittal, Member Secretary, Madhya Pradesh State Legal Service Authority, to please welcome my Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Judge, High Court of Madhya Pradesh, by presenting a planter. Thank you, sir. I now humbly request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, to kindly deliver the welcome address.
My Lord, Honorable Chief Justice Abhay S. Oak, Honorable Judge, Supreme Court of India, My Lord, Chief Justice Suresh Kumar Kaid, Honorable Chief Justice, High Court of Madhya Pradesh and Patron, Madhya Pradesh State Judicial Academy, My Lord, Chief Justice Sushrut Arvind Dharmadhikari, Honorable Judge, High Court of Madhya Pradesh and Chairman, Governing Council, Madhya Pradesh State Judicial Academy, Honorable Judges, High Court of Madhya Pradesh, present here and joined us virtually, Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh and Officers of Registry, Shri Pradeep Mittal, Member Secretary, and Officers of MP State Legal Services Authority, Judicial Officers of District Court Jabalpur, Officers of the Academy, participating Principal District Judges, Judges of District Judiciary who have joined us virtually. Good morning, esteemed dignitaries and distinguished participants. Namaskar. It gives me immense pleasure to welcome you all to this prestigious conference for Principal District Judges. This gathering marks a significant step forward in our journey to ensure justice delivery in its most efficient and equitable form. This conference is one of the most significant programs conducted by the Academy. It serves as a platform for us to engage, reflect, and collectively work towards enhancing our judicial system. As custodian of justice, our district judiciary plays a pivotal role in safeguarding the fundamental rights of every citizen, ensuring the faith of the common man in our system remains unshaken. Through this conference, we aim to delve into several pertinent issues, such as developing an efficient judicial system and devising strategies to achieve organizational goals, addressing key issues in district court administration, particularly the effective management of time, human resources, and infrastructure. We have devised the schedule of this conference with the hope that the participants are able to raise their queries and get redressal. Hence, we have included subjects pertaining to district court administration, legal aid, development in the IT infrastructure, amongst others. The scope of the discussion also includes reviewing the academic calendar of MPSJ and seeking your valuable suggestions for the academy. We look forward to your inputs on subject matters and topics for training, your views on the Jyoti Journal, and other related issues that could help us to refine our approach further. At this juncture, I would like to extend my heartfelt gratitude to our Chief Guest, Honorable Justice Abhay S. Oak, Judge Supreme Court of India, for gracing this occasion with his presence. Despite the connectivity challenges to our city, His Lordship consented to inaugurate the event and address us. My Lord's unwavering commitment to the cause of judicial excellence inspires us all. Thank you, my Lord, for gracing the event. We look forward to your enlightening address on the dynamic role of the District Judiciary as custodian of fundamental rights. I also warmly welcome my Lord, Honorable Shri Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh. My Lord's visionary guidance and constant support in organizing such impactful programs has been vital. I also welcome my Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Chairman, Governing Council, Madhya Pradesh State Judicial Academy. His Lordship has been monitoring the program from its inception and has been a constant source of inspiration. I warmly welcome the Honorable Judges of the High Court present here and connected online. I also heartily welcome Shri Dharminder Singh, Registrar General, officers of the Registry, and all the participating principal district judges to this occasion. Your presence enriches this forum and sets the tone for the constructive deliberations ahead. I also welcome the judges of the District Judiciary who are connected virtually. The primary objective of this conference is to empower our principal district judges with contemporary perspectives and practical solutions to the challenges they face. It is a step towards realizing the vision of an accountable, transparent, and people-friendly judiciary. As we embark on this two-day journey of learning and collaboration, I am delighted to announce that this evening we have planned a cultural night in the honor of all our guests. It will be an opportunity for us to relax, celebrate, and strengthen our bonds outside the confines of structured discussions. In conclusion, I once again thank all the dignitaries, officers, and participants for their invaluable presence and contribution. Interactive participation will be a cornerstone of this conference. We believe that it is it is through active engagement and exchange of ideas that we can derive actionable insights and solutions. Your suggestions are not just welcomed, but are highly encouraged as they form the backbone of this collaborative exercise. Let us make this conference a resounding success through our collective wisdom and shared resolve. Thank you, and I wish you all a very enriching and productive conference. Thank you very much.
Thank you, sir. Your address has set the tone for the deliberations ahead. Moving to the next segment of the inaugural session, I take the liberty of mentioning that Jyoti Journal, a publication of this academy and a widely familiar term amongst all of us, was first introduced in the year 1995 by the founder of this academy, late Honorable Shri Justice U.L. Bhatt. Since then, the journal has been a cornerstone of legal scholarship and knowledge dissemination for the judges of Madhya Pradesh. It is an in-house bi-monthly publication meant for free of cost circulation, exclusive to the judges of Madhya Pradesh. It is noteworthy that this journal was later integrated into a dedicated Jyoti Journal software platform for internal circulation. Over time, the Academy has been increasingly receiving emails and requests for broader access to this valuable resource. In response to this overwhelming interest, the Governing Council of the Academy, under the aegis of our Honorable Chief Justice, decided to make available e-copies of Jyoti Journal to the public, ensuring that anyone who wishes to access its insightful content can now do so. In furtherance of the same, as we also celebrate 30 glorious years of Jyoti Journal, I humbly request our Honorable Chief Guest to fructify this resolution by launching this initiative. Thank you, my Lord. With this initiative, As of today, all the e-Jyoti journals right from the year 2003 shall be available for public viewing on the front page of the website of the Academy. All stakeholders will now gain access to the journal's rich repository of articles, opinions, leading case laws, guidelines, latest amendments, and notifications. We hope with this initiative, the Academy shall contribute in enhancing the legal knowledge of all the stakeholders. Moving further, it is with great honor that I announce that the High Court of Madhya Pradesh is introducing TWARIT, that is, transmission of warrant, summons, and reports by information technology. It is noteworthy that High Court of Madhya Pradesh is one of the foremost high courts to have incepted and executed TWARIT. We are the first state to have framed and notified rules in accordance to Bharatiya Nagrik Suraksha Sanhita 2023 so as to implement TWARIT. I request our Honorable Chief Guest to kindly inaugurate TWARIT. Thank you, my lord. With this inaugural, all the judges across the state shall be able to monitor the status of the processes and warrants issued by their court. I request the IT team to please play a video explaining the details of TWARIT.
Introducing TWARIT, an innovative and transformative initiative by the High Court of Madhya Pradesh for the transmission of warrants, summons, and reports through information technology. TWARIT is a giant leap toward modernizing the legal system. With just a single click, judicial officers can now generate processes electronically by digitally signing, transmit, and also monitor the same through end step. The police can serve and monitor processes electronically without any delay. This groundbreaking solution saves precious time, ensures accuracy, and enhances accountability. Here's what makes TWARIT remarkable: faster and fairer trials. By eliminating delays, TWARIT strengthens justice delivery. Cutting-edge technology, fully aligned with the Bharatiya Nagrik Suraksha Sanhita 2023, it supports secure and encrypted communication. Streamlined operations, it simplifies the process of issuing, servicing, and executing summons and warrants, fulfilling the requirements of Section 530 BNSS 2023. TWARIT is not just a system, it's a vision for a transparent, efficient, and modern criminal justice system.
Thank you. We are confident that implementation of TWARIT shall go a long way in ensuring transparency, expediting the trials, and streamlining legal procedures. Moving to the next segment of the inaugural session, I now humbly request Honorable Shri Justice Sushrut Arvind Dharmadhikari, our Chairman, Governing Council, Madhya Pradesh State Judicial Academy, to please address us.
My Lord Shri Justice Abhay Oak, Honorable Judge, Supreme Court of India, My Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice, High Court of Madhya Pradesh, my sister and brother judges present here and connected online, Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, and officers of the registry, Shri Pradeep Mittal, Member Secretary, and officers of the MP State Legal Services Authority, Shri Krishnamurti Mishra, Director, Academy, and officers of the Academy, participating Principal District Judges, Judicial Officers of District Court Jabalpur, Judges of District Judiciary who have joined us virtually. A warm welcome to everyone. It is a great privilege to address this august gathering of Principal District Judges, the cornerstone of our judicial system. At the outset, I would like to heartily welcome Honorable Justice Abhay Oak, Judge of the Supreme Court of India, for gracing this occasion
with his presence. We are elated to have my Lord with us and look forward to benefiting from his Lordship's address. I also request all the participants to make the most of my Lord's presence and learn from him. I also express my gratitude to the Honorable Chief Justice Shri Suresh Kumar Kaith for his invaluable support and guidance. His Lordship's vision has been instrumental in shaping this conference. As we convene here today, let us take a moment to reflect on the profound importance of District Judiciary, not only as the first interface between the citizen and the judiciary, but also as a bedrock upon which our judicial system rests. The District Judiciary is often referred to as the People's Court. It is here that justice is most accessible to the common man. Your courts are not merely venues for dispute resolution, but an arena where the Constitution breathes life, where the rule of law is upheld, and where trust in the justice delivery system is reposed. The role of principal district judges is particularly significant in this framework. You are not only adjudicators, but also administrators, mentors, and torchbearers of judicial ethics and efficiency. The administration of justice at the grassroots level demands not just technical knowledge, but also empathy, leadership, and unwavering integrity. As chairman of this academy, I wish to stress that in this ever-evolving landscape, the importance of continuous learning and skill enhancement cannot be overstated. Judicial academies such as ours stand as vital institutions in equipping judges with the tools needed to navigate the complexities of modern jurisprudence. Training programs are no longer just about procedural laws. They are about understanding social shifts, adopting technology, and fostering inclusiveness. A robust training mechanism ensures that judges are not only well versed with the law, but also attuned to this changing dynamics of society. This not only enhances judicial efficiency, but also reinforces public trust in the judiciary. The district judiciary faces numerous challenges: heavy caseloads, limited infrastructure, and societal pressures. But within these challenges lies opportunities to innovate, to lead reform, and to exemplify the highest standards of justice. We have attempted to curate a schedule for this conference in which the participants are able to find solutions to their issues. In case there is any issue which remains unaddressed, then I will be there to chair the session pertaining to the academy. Please feel free to raise the concern there. I will be happy to be of assistance. At the conclusion, I would like to add that as leaders of the district judiciary, you have the unique opportunity to inspire your teams to strive for excellence. A well-managed court not only delivers justice swiftly, but also sets a benchmark for accountability and transparency. You have to take care of the judicial officers working under you in such a manner that they are able to reach their fullest potential and are able to serve the cause of justice efficiently. I leave you with the words of Mahatma Gandhi, who said, "The best way to find yourself is to lose yourself in the service of others." Your service to the judiciary is a noble endeavor, and I am confident that under your leadership, the district judiciary will continue to uphold the highest ideals of justice. Let us pledge to uphold the ideal of justice, equality, and integrity with renewed vigor. Thank you, and I look forward to our discussions and deliberations.
Thank you, my Lord, for guiding us and encouraging us to strive for excellence. I now humbly request my Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice, High Court of Madhya Pradesh, to please address us on this landmark occasion.
My Lord Chief Justice Abhay, Honorable Judge, Supreme Court of India, My Lord Shri Justice Sushrut Arvind Dharmadhikari and my colleagues from all three courts, Shri Dharmender Singh, Registrar General, and officers of the registry, Krishnamurthy, Director, Madhya Pradesh State Legal Services Authority, and officers of the Academy, Shri Pradeep Mittal, Member Secretary, and officers of MP State Legal Services Authority, officers of the Academy, participating principal district judges, ladies and gentlemen, good afternoon. At the outset, I want to express my happiness in meeting all the principal district judges. Over a course of these few months of my tenure as Chief Justice, I have had the chance to meet some of you, but I am delighted to address all of you at this conference. The reason is that I recognize the critical role you play in ensuring that the wheel of justice turns smoothly for our society. As Chief Justice, I deeply value and enhance the interaction with the District Judiciary, as it is the backbone of our legal system. The District Judiciary is often the first point of contact for litigants, and your efforts directly influence their perceptions of justice. It is our collective responsibility to serve the litigants and protect their interests with unwavering commitment. Every decision, every action you take in your courts has a profound impact on the lives of the individuals who place their faith in the judiciary. As principal district judges, it is your role to ensure that judicial administration of the district runs properly. You are also the guardian of the judicial officers working under you. It is your duty to ensure that the problems of judicial officers are addressed and each court under you runs smoothly. Efficiently of a team depends a lot on its team leader. Who is a good team leader? I think we can find solution in this court that leadership is not about being in charge. It is about taking care of those in your charge. I want that all of you become the best team leader. An essential aspect of our role is to ensure that justice is not a privilege reserved for few, but a right accessible to all, especially to those who cannot afford it. I urge you to proactively ensure the provisions of free legal aid wherever necessary so that no individual is denied justice due to financial or social constraint. The Legal Services Authority Act is a powerful tool in our hands, and we must leverage it effectively to uphold the ideas of equality and fairness. Furthermore, it is imperative to safeguard the rights of litigants, especially that under trials. Many individuals languish in detention due to delays or lack of legal representation, often for periods longer than the prescribed sentences for their alleged offences. I encourage you to adopt a compassionate and vigilant approach in protecting the rights of the litigants, ensuring timely trial, and addressing any instances of injustice detention. This conference underscores the importance of the collaboration and dialogues between higher judiciary and the district judiciary. Together, we can ensure that justice delivery system becomes more accessible, efficient, and responsive. I encourage you to share your insights, experiences, and challenges openly during this forum. Let this be a platform to learn from each other and build a stronger judiciary for our nation. I thank you for our dedication and services to the cause of justice and for being the custodian of law in your respective districts. Let us move forward with the shared goal of upholding the rights of every litigant, ensuring free legal aid wherever required so that justice is not only done but also seen to be done. Before concluding, I would like to extend my heartfelt gratitude to Honorable Justice Abhay of Judge Supreme Court of India for gracing this occasion with his esteemed presence. I have had the privilege of listening to my Lord's insightful addresses in the past, and today we are fortunate to be guided by someone who embodies immense grace, wisdom, and experience. I encourage all the participating judges to fully embrace this opportunity to learn from His Lordship's address and to make the most of His valuable presence. Lastly, I want to reach out to all the principal decisions. I show of you my steadfast support in addressing any grievances or challenges you face in discharging your duties. Please feel free to approach me wherever necessary. Your work is too vital for any concern to go unheard and unaddressed. Thank you very much. Looking forward to our continued engagement and collaboration. Jai Hind.
Thank you, my Lord, for your profound words of wisdom and motivating us to perform better. Today, we are blessed to have the imminent presence of Honorable Shri Justice Abhay S. Oak, Judge Supreme Court of India amongst us. Previously, His Lordship had visited our academy as Chief Justice Karnataka High Court to chair a session in the All India State Judicial Academies Directors Retreat held in the year 2021. We are deeply honored to have His Lordship amongst us again. I take the privilege of inviting my Lord to please deliver the keynote address.
Good morning and namaskar. It's a great privilege to come here again. As the convener of the program said that I was here in 2021. Honorable Shri Justice Suresh Kumar Kait, Chief Justice of High Court of Madhya Pradesh, Honorable Shri Justice Dharmadhikari, who is the Chairman of the Governing Council of this Academy, sister and brother judges of Madhya Pradesh High Court, the Director of the Judicial Academy, the district judges and civil judges who are physically present and who have joined online. From 2004 onwards, I have been a regular visitor to various judicial academies. I remember in 2004, I addressed not exactly Judicial Academy, but in those days in Maharashtra, we had Judicial Officers Training Institute in Nagpur. When I was posted in Nagpur bench, that gave me first opportunity to interact with the judicial officers of the state and address them on a particular topic. And thereafter, I have been a regular visitor to all judicial academies, Maharashtra, Karnataka, some other states, and National Judicial Academy. I started practice in district court in 1983. My father was a district court practitioner. After 2 years, I shifted to High Court. And therefore, I have seen how judiciary used to function, and I see a huge transition in judiciary. 1983 is long back, more than 42 years back. Two transitions which I have noticed, which I must share with you. One transition is that judiciary has become more inclusive. The young lawyers belonging to all caste and religions, they have started joining judiciary. One very important change which I saw was when we start the process of appointing civil judges. Now almost in all states, more than 50% of our civil judges are now women. This is a very remarkable change which I have seen. 2 years back, I addressed 300 judicial officers in Bihar State Judicial Academy, and about 60% of them were women. So judiciary has become more inclusive. One very important change which I have seen is now the judges are getting very good pay scale and perquisites. I remember when I started practicing, even a district judge could not afford to buy a two-wheeler. Now things have changed completely. Things have changed so good and so well for the judiciary. I remember a few days back, I was in a meeting with senior IAS officers. They were all senior secretaries of the government of India departments for selection of members of a particular tribunal. After our work was over, we were having tea. So one of the senior secretaries of government of India told me, "Sir, I want to raise one issue." I said, "What is that issue?" He said, now a young lawyer who enters judiciary at the age of 26 or 27, his pay in hand after deducting the income tax is something like 93 or 94,000, with all the other perquisites like driver's allowance, education allowance for children, free accommodation, various petrol reimbursement, medical reimbursement. He said that newly joined IAS or IPS officer has pay packet of something like 79 to 80,000, and we undergo very rigorous training. We have to face very tough examination, civil service examination. So why this disparity? So my answer was that judges have a completely different role to play. So you can't compare the role played by judges with the civil servants. And this is a change for the good. In fact, I remember as the Chief Justice of Karnataka High Court, I used to get requests from the members of the judiciary seeking permission to acquire vehicles. And I was really astonished. Of course, there in Karnataka, there is one more facility. I think there is a credit society of judicial officers, and they give vehicle loan at a very cheap rate. But I was very happy to get applications from civil judges, senior civil judges. They wanted to buy a car. Because this is a transition which I have seen, that in 1983 when I saw the judiciary, no one was even in position to buy a two-wheeler. And this is a change for the good. And when we see this change, especially better pay scales, better perquisites, that puts great onus on all of us. Now we don't have complaint about our pay scales and the other facilities we get, we are expected to do better quality justice. That is the minimum expectation from us. Today's topic is a very interesting topic, dynamic role of district judiciary as custodian of fundamental rights. Recently, we celebrated a very important event of acceptance of final draft of the Constitution, 75 years, on 26th of November 24. And I was invited to address law students, judicial officers on this topic. I realized one thing when I became judge of the Bombay High Court, that the basic judiciary, the real judiciary in our country is our trial and district judiciary. And as I grew old as a judge, I felt that we are neglecting our district judiciary. Those who are following the judgments of the Bombay High Court, I remember Chief Justice Mohit Shah constituted a bench, special bench presided over by me. For 5 years I was presiding over that bench, which dealt with infrastructure of our trial and district courts. And we passed several orders. We directed security to be provided to the judges, and several orders were passed, running into hundreds of pages. And then I realized in 2006 when for a year, I dealt with regular second appeals under section 100 of CPC. So with the help of one of the organizations, one of the registrars helped me, we conducted a study. I'm talking about 2006. We conducted a study about how the civil suits travel. So the study showed, broad study, it was a very broad study. In those days, this modern equipment was not available. The study showed that about only 70% of the litigants against whom judgment of the district court in appeal under section 96 goes, only 70% of them come to the High Court by way of second appeal. And after second appeal comes to an end, about 60%, only 60% of litigants, they go to Supreme Court. So statistics at that time showed that after first appeal under Section 96 decided by District Court, only 70% go to the High Court and 30% accept the judgment. They may be accepting it for different reasons, because lack of resources or various other reasons, but fact is that in those days, I don't have the current statistics, 30% of the litigants who are parties to civil suit used to accept the decision of the District Court as final. So when I went to Karnataka as the Chief Justice, I was sworn in vacation. First administrative order which I passed was that hereafter in Karnataka state or Karnataka judiciary, no court will be referred as a lower court or subordinate court. Though unfortunately, Chapter 6 of Part 6 of the Constitution has heading of subordinate court, but I passed that order that in Karnataka, the Civil Court Act provides for appeal against orders of a civil judge to a district judge. So I said nobody will address any judge as a lower court or subordinate court. And in fact, we had branches in the High Court, lower court branch. So I directed that name should be changed. Then we used to use a phrase, lower court record. So I said, no, you should not use phrase lower court record, it should be trial court record. Because calling any court as subordinate court or lower court is totally inconsistent with ethos of our Constitution. And in fact, I could not have directed, but I requested my sister and brother judges, while writing judgments, please refer to court as trial court or civil court or district court, sessions court, but don't refer to any court as subordinate court or lower court. The reason is, there is one more reason for this. When we talk about constitutional courts, we always talk about Supreme Court and high courts. But we ignore that after Constitution came into force, every court in our country, right from Supreme Court to Civil Court, their existence is on the basis of Constitution of India. And why, I don't know why we call for all these years only the Supreme Court and High Court as constitutional courts, because if you see, there is one chapter which is part of Part 6 of the Constitution, which is heading subordinate court, and which talks about appointment of district judges, it talks about appointment of civil judges. You know all those provisions. So there is a foundation for establishing our civil courts and district courts in our Constitution. So therefore, all of you must always remember, I have said this in various judicial academies, that like High Court and Supreme Court, you are also part of Constitutional Court, because your existence is created by the Constitution with effect from 26th of January 1950. In fact, in Supreme Court also, I used to get office reports that LCR not received. So I passed a judicial order, don't say LCR, say record of the trial court record instead of lower court record. And one mistake, in one of the functions I was called upon to speak, that where we have gone wrong during last 75 years, whether we have fulfilled the aspirations of common man, the expectations of common man from the judiciary. And my personal view, I have said so in various, on various platforms, that we have not been able to fulfill the expectations of common man from judiciary in independent India, judiciary which is established under the Constitution. And one of the mistakes which we committed, that is my personal view, it may not be correct, is that when we discuss judiciary or justice delivery system on various platforms, we discussed only High Courts and Supreme Court. We never bothered to even discuss our trial and district judiciary. And that was one mistake we committed, and therefore there was some neglect on our part during the last 75 years of our trial and district judiciary. As the Chief Justice rightly said, these are the courts of common man. Common man has to approach these courts. I always give one example. Under Indian Succession Act, there is a provision for grant of succession certificate. Even a common person, somebody, some woman losing her husband, she wants to get pension or she wants to have access to the whatever money her husband left in the account. such person is required to come to a civil court to get succession certificate. And this is one litigation where there is no choice but to come to the court. Several such examples I can give. So a common man, it is a common man's court, and therefore common man has great expectation from our civil courts and our district and sessions court that they will get justice. Now, in the context of constitution and the fundamental rights, all of us must remember that we as judges must understand what are the ethos under our constitution. In fact, if you see Article 51A, newly introduced article, I think clause 1 of that article says that all of us, it is the responsibility, it is the duty of every citizen of India to respect not only the constitution but the ideals of the constitution. So the scheme of the constitution is that whatever are the ideals under our constitution, we are bound to not only respect but follow those ideals. And for understanding what are the ideals under our constitution, we need not read the entire book of the constitution. Even if we read preamble, it is sufficient. There are 4 ideals, 4 basic ideals. One is justice, liberty, equality, and fraternity. And apart from that, 2 very important words used in the earlier part of preamble, that ours is a socialist democratic republic. So word socialist and now word secular has been added. So socialist and secular are the 2 most important words in our constitution. So secularism, of course now it is basic structure of the constitution, but these are the ideals: secularism, socialism, justice, liberty, equality, and fraternity. These are the ideals of our constitution. We need not read the entire constitution. And once we talk about liberty, once we talk about justice, naturally we must talk about fundamental rights. But today we can say that right to get justice is a right covered by Article 21, because it is ultimately right to live with dignity, human dignity. Therefore, right to justice is implicit. And I'm not talking about a simple right to justice. In a case where there is an offense committed, even the victim of the offense has right to get justice. That is also a part of justice. So therefore, these are the basic ideals of the constitution, and when we sit as judges, we must not only respect those ideals, but we must try to implement those ideals. Today we are in the era of use of technology, and National Judicial Data Grid, which is one of the best things which could have happened. If we have access to National Judicial Data Grid every morning, that always reminds us about the task ahead of us. Today morning I had opportunity to go to National Judicial Data Grid. In District Judiciary in Madhya Pradesh, the total pendency is about 20,32,854 cases, out of which about 4,09,000 are civil, and 4 times of that, that is 16 lakhs, are criminal cases. And there is one more slightly worrying area, is that about 13% cases are undated cases. I'll talk about it little later. And about 18% cases are more than 5 years old. Now this percentage of 18% is much lower than many other states like Maharashtra, Uttar Pradesh. The percentage of 5 years old cases is much higher. So once we look at these figures on the National Judicial Data Grid, we become very clear about the challenges we face. Now talking about your duty as custodian of the fundamental rights. Now the first duty arises by virtue of Article 14. I'll elaborate that. One thing which I realized during my journey of last 21 years as a judge of the Constitutional Court and 20 years as a lawyer is that we are not able to set our priorities right. Which cases should be given priority? Are we going to give priority to so-called commercial cases? Are we going to give priority to arbitration cases? Or are we going to give priority to common man's cases, that is, cases which are there before the judicial magistrates and or civil judges? So we are not able to set our priorities right. And I must take responsibility for not allowing our trial and district judiciary to set their priorities right as a judge of the Constitutional Court. We are the ones who sit in the Constitutional Court, and when some litigant comes before us, we are the ones who say, all right, this case you decide within 6 months, decide within 9 months, decide within 1 year. When we pass such orders sitting in the Constitutional Courts, we don't realize that what is the pendency before that court. I have seen this happening. We sitting in Bombay High Court while rejecting the bail applications used to say, all right, decide the case within 6 months, without realizing that even charge is not framed. And then I realized after looking at the figures that somebody comes before us, we say, all right, his case will be decided within 6 months. But at grassroots level, before that sessions court, I found that we are directing them to decide a newly filed case within 6 months. But there are people waiting in the queue. Very old cases are there. And therefore, sometimes a litigant used to carry impressions. Today, he carries such impression that if you are able to, if you can afford to go to higher courts, say High Court or Supreme Court, you will get an order that his case should be given out of turn priority. Of course, some of you must have seen. Now, fortunately, I am party to a Constitution bench judgment. I could get an opportunity to write that judgment where I have said that no constitutional court should treat our trial and district court as a subordinate court, in the sense that direct that court to decide some case within a time-bound schedule. I have said that this should be done in exceptional cases, very rare and exceptional cases. Because when we have a queue of litigants waiting before us, we can't say that we'll pick up one because he has gone to Supreme Court. He could engage a very successful lawyer and get that order. Therefore, by a verdict of the Supreme Court, we have stopped this. And one of the main reasons is Article 14. Because for us, every litigant is the same. We can't give priority because, so it's a commercial dispute. I have my own reservations about giving priority to commercial cases in a country like India, where poor need more justice. In fact, I said so in many of my judicial orders in Bombay High Court and in Karnataka High Court. So our priorities have to be set right. Now, how do we set right those priorities? So basic rule has to be that seniority has to be followed, in the sense oldest litigation must get priority. Now, this is in conformity with Article 14. That's the Article 14 which protects every citizen against arbitrariness. Of course, we must categorize cases which require priority. There are statutes like, for example, Negotiable Instruments Act, which provide for outer limit of deciding a complaint. There are statutes like this matrimonial legislation, Hindu Marriage Act, etc. There is a time limit. We have to abide by that time limit. And otherwise also, we must have our priorities. For example, one example I'll give you. Now, one category of litigation which is going to affect our judicial system, it has already adversely affected judicial system, is the rise of matrimonial disputes. Now, sitting in Supreme Court, we get those transfer petitions. Now, the situation is so bad that there is one matrimonial dispute. It creates 4 to 5 grassroots level litigations. One litigation is, of course, either proceeding for divorce or restitution of conjugal rights, or sometimes both husband and wife file different proceedings. Then there is a complaint under 498A, then section 125 of CRPC, section 12 of DV Act. And now recently, I have come across several cases where now there is a prosecution under IT Act, because husband and wife, those who belong to a particular class of society, they exchange WhatsApp messages. On the basis of that, prosecution under IT Act. So one matrimonial dispute creates 4 to 5 grassroots level litigations, and then you know what happens. Revisions, appeals, writ petitions, 482 petitions, 227 petitions, and ultimately 136 petition before the Supreme Court. Husband and wife file cases at different places, so transfer petitions either before the High Court or before the Supreme Court. Now, this is one litigation which is someday judiciary is going to crumble under pressure of this litigation. So therefore, this is one priority area, and I always believe that this litigation must be given priority for this reason. One matrimonial dispute affects 3 families. One is that small family of husband and wife, and if there is a child, it is still worse. Child is the worst sufferer. The second family, which is other 2 family also get affected. One is the family of the wife and other is the family of the husband. So 3 families get adversely affected by one matrimonial dispute. So these are the disputes where we should be given priority, and not only we should rest at giving priority. At the earliest, we must try and resolve the matrimonial dispute. That's the need of the hour. The best period for settling matrimonial dispute, on the basis of my experience I am saying, I may be wrong, is when the case is at initial stage, when a fresh case is filed, maybe under 498A, maybe a maintenance petition. That is the stage at which, if judges intervene, judges refer to mediation, judges themselves mediate, that is extremely helpful, because as the time grows, time factor comes into picture. Sometimes litigation becomes 5 years old, 10 years old cases, and then one of the parties feel that my spouse has spoiled my life, therefore I'll spoil his life and I'll not compromise. We find it difficult to settle the cases in Supreme Court. Of course, Supreme Court, we have advantage. They know that we are in the last court. So somehow we are able to prevail upon them. So therefore, this is one priority area where you must be giving utmost priority. The other priority area in criminal matters, of course, all of us know that when the accused is in jail, there is jail cases, that priority area. So several priority areas, for example, Section 12 of DV Act, 138 of the Negotiable Instruments Act, law has fixed some time limit. That also I have told chairpersons of the Law Commission that this one amendment of the Negotiable Instruments Act has affected our judiciary. Go to any metropolitan city in India and go to any magistrate's court, you will find 50% of the cases are under Negotiable Instruments Act, because basically which is something which is civil wrong, we have converted into a criminal offense. But that's the mandate of the statute. Therefore, we have to go by that. Maybe the legislature felt that the commerce is affected. Somebody who gives check in business transactions, if the check is dishonored, the entire commerce is affected. Therefore, legislature in wisdom have come out with that amendment. And that is one case where, again, there is lot of scope for settlement. And therefore, while our judicial magistrate must try to resolve by conducting the trial, but also we must make effort for settlement. Then comes a very, very important area of criminal trials and bail applications. Now, criminal trials, I have been now, as I said, I have presided over bench of Bombay High Court dealing with criminal appeals for a long time. I sat on the bail jurisdiction, and after coming to Supreme Court, about 50% of cases which I deal are criminal cases. The situation worries me in, like this. In Bombay High Court also, I remember one of my last sittings in Bombay High Court was of criminal appeals. In that one particular session, I remember we had granted acquittal to many cases, about 11 or 12 cases, where person had undergone 14 years, 15 years or 12 years. And mind you, those were the cases where there was no evidence. It was not a case of benefit of doubt. And this happens in Supreme Court. One case I came across where on the face of it, any court should have granted acquittal, but there was a death sentence converted by High Court into life, and then we had to acquit the accused. I am faced with one worry. The worry is, if this is going to happen in independent India, where law is very clear, barring those special statutes, that there is a presumption of innocence. Tomorrow, some litigant will come to the court and will say, pay me compensation, because you are acquitting me at the stage of Supreme Court or High Court, and I have spent 12 years of my life or 13 years of my life in jail. My entire family has been spoiled. My sons and daughters cannot get married because of the stigma. This aspect we have to keep it in mind. In fact, other day I went to one judicial academy last year. I always have interactive session in judicial academies. So it was a batch of direct appointed district judges. And therefore, I was discussing with them how to deal with criminal cases. So I asked one newly appointed judicial officer who was a graduate from one of the national law schools, and I had seen their profile. He had one of the brightest careers. So I said, when you sit as a session judge and there is a trial of a crime comes before you, what you are supposed to do? His immediate answer was, I am supposed to decide, and I am called upon to decide, he used those words, whether the accused before me has committed the offense. I said, you need change of approach. When we sit on the criminal jurisdiction, we don't make an endeavor based on our perception whether this man has committed an offense. That's not our function. Our function is to see what is the evidence on record, appreciate that evidence, and decide whether the evidence on the record establishes the guilt of that accused beyond a reasonable doubt. That is the function which we discharge as judges. We should not endeavor into the hypothesis that, look, whether this man has committed the offense. No. Our approach should be to see the evidence. If there is a legal evidence on the basis of which, within the parameters laid down by the law, a person is found to be guilty, you must convict him and you must give him appropriate punishment. If you start imagining, if you start looking at a criminal case, look, these witnesses are turned hostile, but somehow this man must have done it, then you end up in giving moral conviction. In fact, one of the judgments I said, it is not permissible for our judicial officers to give moral conviction. It is not permissible at all. Because basically, when you sit as a judge, your duty is to see whether within 4 parameters of law, guilt of the accused is proved. That should be your approach. Coming to the bail jurisdiction, I was discussing hypothetical cases in one of my sessions in Judicial Academy. I just gave 4 or 5, a short note was prepared as I had circulated earlier. So I discussed with judges that what would you do in such situation, whether you will grant bail or you reject the bail. So in one case, one of the younger session judges, he said, sir, I will not grant bail in this case. I said, why? He said, you know, this man is very influential, and therefore I am sure that all witnesses will turn hostile. So at least I will ensure that he remains in jail for a few years, but eventually he is going to get out. So I said, this is absolutely wrong approach. This is absolutely wrong approach, because you must understand why we detain under trials in prison. And there also, in case of now, law of bail is concerned, is very clear. What are the parameters for grant of bail? All of you know. It's a very well settled law, right from Justice Krishna Iyer's famous verdict. So when you deal with bail application, don't go into any extraneous considerations. If within parameters laid down by the law, a person is entitled to bail, it is your duty to release him on bail. Otherwise, you are guilty of violating his fundamental right under Article 21. For extraneous reasons, never reject bail application. I am not saying, see, normally I don't know why we use this theory that so-and-so is liberal in granting bail. I disapprove this. I mean, there is nothing like liberal approach in grant of bail. We must think of saying that here is a judge who strictly follows the law laid down by Supreme Court and High Courts when he deals with bail applications. So there is nothing like liberal approach. The approach should be legal. That's the most important thing. And today I see a scenario. I'm talking about cases triable by judicial magistrate first class, where charge sheet is filed. Madhya Pradesh is also a big state. Now, I just now discussed the figures of pendency. So we know there is huge pendency, barring few small places where there are few cases, huge pendency of cases before our judicial magistrates, because judicial magistrates don't deal only with trial of offences. They deal with 125 cases, DV Act cases, so many other cases they deal with. So now today we have a scenario where a charge sheet is filed, case is triable by a magistrate, there are say 25, 30, 35 witnesses. People don't get bail even in the High Court, they have to come all the way to Supreme Court. So when we talk about our constitutional obligation, we ultimately don't be under impression that it is the responsibility of only Supreme Court judges and High Court judges to enforce Article 21. The enforcement of fundamental rights starts from the courts of our magistrates, our session judges. In fact, I always feel that you are the ones who conduct trial. And while you conduct trial, you have to conduct trial in a very fair manner. Fair manner in the sense that you must give proper opportunity to prosecution also to lead evidence. You must give proper opportunity to defend. So you are supposed to conduct trial in a fair manner, and requirement of conducting a trial in a fair manner will have to be read into Article 21. And therefore, your courts, the courts of trial judges and district judges, these are the courts where actually you are supposed to give effect to the fundamental rights, very valuable rights made available under the Constitution. And I always implore the young judicial officers to read debates in the Constituent Assembly, and especially one debate on fundamental rights. And you today, of course, time is short, what Dr. Ambedkar said about necessity of having fundamental rights. Then you will realize what is the importance of fundamental rights. So, when we talk about please remember that you are the ones who are under obligation to enforce the fundamental rights, especially Article 21. And while conducting the trial, I always proudly say that our country, after independence, we conduct trials in very fair manner, and therefore Ajmal Kasab was given very fair trial. High Court appointed one of the very successful lawyers who used to practice on the criminal side as amicus curiae to espouse the cause of Ajmal Kasab. So we should be proud of this, that our system is so fair. I am not naming those countries. We talk about the great speed at which one of the Asian countries disposes of commercial matters or arbitration matters. Someday I had occasion to go through their laws. Now there is no concept of fair trial in that country. If the police make allegation of commission of offense, it is virtually accepted as gospel truth by the courts. And our country is different. Our country, we give fair trial. Now, while I discuss, because fair trial is again a constitutional concept, please remember that when we talk about fair trial, the trial has to be fair not only to the accused but also to the prosecution. Because ultimately, when you sit in the court, there is an offense committed, so there is a victim of the offense. Or if there is a case of murder, there are legal representatives of the victim. So our duty is to enforce law, and when we enforce law, we have to do justice to the society also. Because as I said, that if there is no evidence, it is our duty to acquit the accused. But at the same time, if there is a legally permissible evidence which proves the guilt of the accused, you must ensure that accused is adequately punished, because societal rights are also involved in this. And therefore, we have to be very, very cautious when we conduct trials. Now, one area I just want to highlight, which I have highlighted in all judicial academies, that area is recording of statements under section 313 of CRPC. Cases after cases I have seen in High Court, I have seen in Supreme Court, our judges are committing mistakes. What is the object of 313 statement? That every circumstance which appears in evidence against the accused has to be put to the accused in the language known to him. Because there are cases and cases where the accused who is before you, he may not be able to understand the language of the court. He may be a person coming from other state. Now, 313 statement is one of the most important things in the process of trial. We can't neglect it, because there are cases and cases where after 20 years sitting in Supreme Court or High Court, we find that the material part of the testimony of the witnesses on the basis of which conviction has been granted is not put to the accused. Now after 20 years, this defect is a curable defect, though defect goes to the root of the matter. But after 20 years, you can't remand the case and tell the accused, now you have to answer the circumstances appearing against you in respect of the incident which has taken 25 years back. So this is one area which I want to highlight, that it is because of inadvertent mistake or mistake committed under pressure by our session judges or our trial judges that cases result into acquittal. And that's the most important thing, that even the victims have fundamental right to ensure that justice is done, and even the accused has fundamental right. So therefore, these are the few aspects we should all of you should please keep it in mind in the context of the Constitution. Now today there are many principal district judges here. Very important function of the principal district judges is to make jail visits. And if you make very effective jail visits, you learn so much from the jail visits. I can share my experience. As the chairperson of the Maharashtra Legal Services Authority, I decided to visit all central prisons. I visited 2 prisons and then I realized I am committing a mistake, because information about my visit was given 2 or 3 days or a week in advance. And I realized I should not be doing that. So I started a different practice. I started visiting central jails after giving notices, say about 2 or 3 hours. And then I had those interesting experiences. I went to a very prominent jail where so many freedom fighters, including Mahatma Gandhi, was detained. So that jail, the inmates used to run a radio station. So they called me, they said, sir, we want to ask you a few questions. So I went there, my interview was conducted. Then we started taking a tour of the jail. There was a jail superintendent with me, some other jail officers, and the person who conducted my interview, the convict, he was a life convict in fact, he was following me, and all jail officers were telling him to go away. So I thought that I should talk to him, he wants to say something. So I told the jailer that please bring him, I want to talk to him. He said only one sentence, and I was taken aback by that sentence. He said, sir, the jail officer who is walking with you on the right hand side is the most corrupt jail officer we have. And then I made discreet inquiries that turned out to be true. So many things you realize if you make a jail visit. Now we have legal aid lawyers visiting the jail. They are supposed to file bail applications. They are supposed to give legal aid. How effective it is. That you can realize only if you visit jail. I remember recently, subject to correction, bench headed by Justice Gawai has observed that it is our duty to provide legal aid to poor, but legal aid should not be poor. I have said in different language, I have said that if there is constitutional right to get legal aid, that legal aid should be quality legal aid. But today we have a scenario where lawyers don't cross-examine the witnesses at all. So if as PDs you are active, you take your Secretary of the District Legal Service Authority to jail and inspect the jail without prior notice or give short notice. So many things will be revealed. I found jail visits was a very, very learning experience. And only after I started visiting jail, I realized what a jail means. Otherwise, I practice in a district which is adjacent to Bombay. Then I practice purely on civil side in High Court. That also confined to Bombay. We don't see the realities of life. So that's very important function of PDs to visit the jails. Now coming to functions of PDs, I love to address civil judges, newly appointed civil judges. So normally when judicial academies call me, in fact there are standing instructions given judicial academy in Maharashtra and Karnataka. When a new batch comes, please inform me, I'll come. So one of the classic grievances which they make before me, they say that, sir, my PDs is not giving me good treatment. I don't get access to PDs. He doesn't give me appointment. I'm not treated with dignity. I give him totally different answer. I always tell him that, look, I spent 21 years in judiciary. In judiciary, of course, we have ideals before us. There are great judges under whom we work or with whom you work, and you learn so much. But there is negative learning also. You always learn how one should not behave. I said, now please remember, you are young, that judge was 26-year-old woman judge. I said, please remember, you are bound to become PDJ. And then you remember how badly you are treated by your PDJ. So don't commit that mistake. So this is the way you learn. See, as a principal district judge, firstly, I must tell you, we are all judges under the constitutional code. As I said, that no judge of a civil court or district court should be addressed as a judge of a lower court or subordinate court. Please remember that though you are a PDJ, you are PDJ because you are senior, you have spent some time in judiciary. Therefore, you become PDJ. So, you are head of the family. You are not a superior officer of a newly appointed civil judge. So, your approach should be as head of the family. You should be having dialogue with the junior most member of judiciary of your district. Because ultimately, you are their guardian. You, ideally, a principal district judge should act as a guardian. Because one more thing, because why you must act as a guardian, that you are the eyes and ears of High Court. If there are some complaints against a civil judge or a session judge, ultimately High Court depends upon your opinion or your views. So therefore, it is very important that the principal district judge acts as a true head of the family, and he should have a very cordial relationship with all the judges who are working with you in the district. Only if this happens, you are able to improve the performance of the judges, and that's very important. Actually, no civil judge should have any cause of complaint against a principal district judge. If principal district judge behaves truly like a guardian, then there is no occasion for making a complaint. So there has to be a family relationship built by PDJ with the civil judges, judicial magistrates, senior civil judges, etc. There are a great erudite retired judge of the Bombay High Court. After I became judge of the Bombay High Court, I just went to him for guidance, because one who has practiced for 20 years as a lawyer, the transition is so difficult when you become a judge. Very important piece of advice he gave me, which I always give it, transfer it to the PDJs. He said, you please remember one thing. In various states, there are different concepts. There are guardian judges of districts. Some states, there are administrative judges. Names are different, but the duties are the same. So, whenever you go to a district place or taluka place, if the principal district judge or the judge heading that particular, say, taluka court, if he invites you for a cup of tea or breakfast to his house, never say no. Never say no, because it gives you, there are two advantages. One is that for that judge, it's a great honor that a sitting High Court judge comes to his house. Secondly, when you go to his house, you know the lifestyle of a judge. You know what is the culture in his house. You understand that something needs to be done, some counseling is required. So similarly, I always tell the PDJs that if you go to a taluka place, there may be a district judge heading that taluka, or there may be a senior civil judge or a civil judge. If you are invited, never hesitate to go to the house of a judicial officer, because that is how, there are two advantages. As I said, you know the culture of that judge, you know the atmosphere in his house, but at the same time, you create a bond with that judge. That judge will always respect you. If as a PDJ you go to his house, his or her house. So that is absolutely important. And then one more thing, one more word of caution. As I said, now there are 50% or more than 50% of our civil judges are women. And therefore, it is your responsibility to see that these women civil judges are respected. And we face a situation. I'll give you an example. I was member of the Governing Council of Maharashtra Judicial Academy. Then we saw 40-50% of women judges coming as civil judges. So we amended our rule and we provided that if that woman officer has a young child, either her mother or mother-in-law will be permitted to stay with her in the Judicial Academy to take care of the child. So these women judicial officers, they have their own issues. They are also equal, I am not saying that, but you must be very careful while dealing with women judicial officers, because still we live in a society where sometimes a woman is supposed to look after her house, supposed to look after members of the family. That's the grassroots level situation. So that one area you must remember, that now so many women judges are coming to our judiciary. Now they have to be treated with great deal of respect, and you must understand the problems which they face. And last few things as a constitutional duty, that your function, one of the crucial roles you play is as the chairman of the District Legal Services Authority. One of the greatest areas where we are lacked, we are far behind, that is about legal literacy. I have conducted 3 legal aid fairs as a chairperson of the Maharashtra Legal Services Authority in the most backward areas. One was in Naxalite dominated area of Chandrapur district in Maharashtra, which is a border district for the state. One was in a very remote place in Marathwada. One was in the remote place in Konkan area. I was fortunate enough to work with NGO as a lawyer. That particular NGO had actually adopted few villages in a very remote place in Raigad district of Maharashtra, and those villages were dominated by scheduled tribe population. If you start legal literacy workshop, you go to villages, you realize one thing. Say today, we always talk we see so many cases that, say for example, section 498A. This is a provision which is misused. Every day we say that. Even SC/ST Act, in some cases we come across, the provisions are misused. But our problem, the greatest challenge before our system is, of course, getting rid of huge arrears. Our greatest problem is that still today, 75 years after Constitution came into force, there is last section of our society which silently suffers injustice, maybe due to social backwardness, economic backwardness, various other conditions of the society. So if you interact with paralegal volunteers who go to villages, you realize that there are very genuine cases where woman is treated with cruelty in connection with demand of dowry. But those cases don't come to the court. As I told you, I'm talking about 1989-90. As a young lawyer, we used to go on every Sunday to a village which we had adopted. There were tribals. Now, so many tribals were subjected to offences under the Act, but they were not aware. They were not aware that a person can be prosecuted who commits offence under the Act. Now, this great drawback in our system, that today we face a huge challenge of docket exclusion. Only way is that our legal services authority become very active and they start massive legal literacy campaign. That people, ultimately this Domestic Violence Act, this act is enacted for our women who stay in villages, live in oppressed conditions. If they don't know the provisions and if they don't have access to legal aid mechanism, they won't be able to come to the court. So, this is one area where principal district judges, for that matter, all of us must devote attention, that legal literacy work is very important work which is part of our legal services authorities. And last thing, all of you must be remembering that now we have devised action plan for disposal of old cases. And we are monitoring in the Supreme Court. The idea is that we should get rid of old cases. And principal district judges are entrusted with the responsibility. We get the reports and we monitor those reports. But please remember one thing. Please impress upon your judicial officers that the idea is to get rid of old cases, 25 years cases, 20 years old cases. Idea is to dispose of those cases in accordance with law. It should not be that there is an old sessions case or a old civil suit where you don't grant adjournment even on a reasonable ground, because the direction of the Supreme Court. The idea is not to encourage judges to conduct hasty trials. Idea is that in accordance with law, priority should be given to these old cases and cases should be disposed of. So don't misunderstand that the meaning of the action plan is that you don't grant adjournment. There are cases which are coming up. Other day, I went to a state judicial academy. I had interaction with the judges of that high court. They said there are cases coming where somebody is sick and therefore adjournment is sought for recording of evidence. The judges are not granting because they say that there is action plan by the Supreme Court. So that's not the idea. We are not going to penalize anybody if you don't follow that schedule. The idea is to project our judiciary in better manner, to project our judiciary which shows concern for these very old cases, 20 years old cases, 25-year-old cases, where people are waiting with great hope that they will get justice. So please understand the correct meaning of this action plan. The correct meaning of action plan is to give a better face to the judiciary. And before I conclude, I always believe, and I have seen this, as a Chief Justice of Karnataka High Court, I visited almost all district places. I used to have direct interaction with the judicial officers, and my rule there was I used to ensure that the Registrar General will sit outside, PDJ will sit outside, and I used to have one-to-one interaction with judicial officers along with the administrative judge of that district. And I have seen, as a chairperson of Legal Service Authority, I attended functions of many NGOs, that today we must accept, and unless we show that acceptance, we won't be able to improvise, that we don't carry particularly good image in the mind of common man. Common man still has great expectations from us, but somehow we are not able to fulfill the aspirations and expectations of common man during last 75 years of existence of the Constitution. And that is really the great challenge before all of us. I am saying all of us, including those who sit in the constitutional courts, that how do we satisfy the common citizen of this country that this legal system will render quality justice to everybody, and this legal system will come to assistance of everybody who needs justice. So somehow during last 75 years, we are not able to create that kind of a picture. So that's the huge challenge before us. So I conclude, I thank Chief Justice Suresh Kumar Kait for giving this opportunity, and office bearers of the Judicial Academy. I have very rarely met your Chief Justice, but I can say that he must be a very disciplined man, because whether it's a very bad summer or bad winter, he never missed his morning walk for 1 hour, and that is the place where we used to meet. So that shows that he's a very disciplined man, because that's my perception, and perhaps that is the only reason I claim that I am a disciplined man, just saying in a lighter vein. So I thank all of you for giving me this opportunity. Thank you.
Thank you, my lord, for your thought-provoking and enlightening address. Your exemplary vision has been instrumental in shaping our judicial system. Esteemed gathering, Honorable Chair has expressed its desire to interact with the participants. If there is any question you would like to ask to the Honorable Chair or give any suggestion, then you are cordially welcome.
Sir, sir.
I expected members of registry to close their ears to ask questions. So feel free to ask any question.
Sir, my name is Rajiv Kumar Ayachi, Principal District Judge from Bhind, sir. Sir, MP is a very large state, sir, and so many districts. The taluka, tehsil places are at very distant place from district headquarters, sir. Even sir, 90 kilometers, 100 kilometers, sir. Sir, on one hand, sir, it is a need to establish a session court there to facilitate all the people of the local area, sir. And on the other hand, sir, I'm not talking about the lawyers of the district court and high court, but particularly in, sir, taluka court, there are lawyers जो सर हमारे लिए एक जो cases में, sir, they are not doing up to the mark, sir. So, what should we do to motivate them, sir?
uh, in every taluka you get demand that we want a court of a district judge. That's pan-India situation. And for that, of course, every high court has its own criteria fixed, number of cases. The distance also is one of the criterias. As the Chief Justice of Karnataka High Court and even Bombay High Court as senior judge, we used to discuss this issue that this is a place where we should have a district court. Maybe because there is more pendency. And secondly, it's a remote place where the litigant can't, it's very difficult for litigant to travel up to a district place, and therefore there should be a court of district judge. So this issue was always raised by some of my colleagues that look, the quality of bar in taluka places is so poor, and if we establish district court, we'll not get quality lawyers. But my experience for last 21 years has been that if you establish a district court in a taluka place, the High Court administration must ensure that a very experienced and seasoned judge is posted there. Only if the district court is established at that place, slowly and slowly, the standard of the bar rises. The seniors who are practiced for 25 years, 30 years, they may not improve, but they are younger lawyers. If they see, if they get opportunity to appear before district judges, the standard automatically rises. I have seen this in Maharashtra. We had Aurangabad bench established in 1981. And it's a very unique thing that a member of the bar challenged the order of Chief Justice establishing Aurangabad bench, and a bench of Bombay High Court struck down that decision. And then Supreme Court restored it. That was the argument that look, there is no quality. Now, 81 the bench was established. I sat there in 2007 and then 2012. I could see phenomenal improvement in terms of quality. So quality, ultimately, we as judges also are responsible to raise the standards of the bar. And it is actually our duty to ensure that standard of the bar is raised. So therefore, if High Court administration, based on criteria, decides to establish a district court at a taluka place, we should not be worried about quality of the bar. It will automatically rise, provided we make some efforts.
आई एम पी के प्राण, प्रिंसिपल डिस्ट्रिक्ट जज बैतूल। जैसा कि माननीय ने कहा कि हम कमिटेड हैं अपना कॉन्स्टिट्यूशनल ड्यूटी से फेयर ट्रायल के लिए, और माननीय ने एडमिट किया, हम सब एडमिट करते हैं। तो इन दैट केस इफ देयर इज विक्टिम कंपनसेशन स्कीम, व्हाई नॉट एक्यूज कंपनसेशन स्कीम, स्पेशली in a case when charge sheet is submitted and we judge discharge the accused, and we when we go through the record we find that the accused was in jail for 3 months or 4 months, even then we could not make a charge against him. Sometimes we make charge, try, and on this basis of same evidence we could not convict him. So why not, we said we should take the responsibility to compensate the accused in totally false and frivolous cases. Why not? If it is our constitutional duty, why you are going back in our constitutional duties? Why not we commit to accused compensation scheme?
Actually, very valid issue you have raised. That's what I expressed myself, that someday we'll have a scenario where some accused after acquittal goes to Constitutional Court and seeks compensation by invoking Article 21. Now, this is an area where, there are many nuances in this. Where there are 4 or 5 categories where we get acquittal or even we discharge accused. Now, for example, NDPS Act. Now, NDPS Act, there are acquittals granted or even discharge granted by high courts or by special courts because there is non-compliance with section 42, 50, etc. Then there are cases where, for technical reasons, which I said a few minutes back, that after 20 years of trial, we find that section 313 statement is not recorded properly, and then we grant acquittal. There are acquittals granted on the ground of benefit of doubt. So perhaps conceivably, only those cases where there are findings recorded by competent criminal court, that this was some kind of a malicious prosecution or a prosecution where there was no evidence against the person. So only in those rare cases perhaps something will have to be done. But you know, it takes time in our system to accept this, because this will require the support of the government. Now, if some government decides to come with the scheme for payment of compensation to those who are acquitted, they have their own political considerations. But the point you raise is very valid point, that why somebody should be prosecuted and somebody is arrested, his family is destroyed, and then ultimately get justice, belated justice, that there is no evidence against him. Something will have to be done, but perhaps to begin with, when cases come before the Constitutional Court for grant of compensation, those cases will have to be considered. But in our system, it will take long time to develop this kind of mechanism. But on principles, as I say, you have a valid point.
मेरे समक्ष एक केस ऐसा आया, मेमोरेंडम स्टेटमेंट अंडर 27 एविडेंस एक्ट के तहत ही वाज मेड एक्यूज्ड एंड नो एविडेंस वाज देयर. ही इज ए डिसेबल्ड पर्सन and he went in jail for more than 3 months. Even admitting all the evidence at the stage of bail, no offense is made out against him. No offense at all. So whether he should not be compensated? And we are, then we judges are not fulfilling the constitutional duty. We are disabled.
This has been already replied. That should be
Thank
there, right?
In what way it should be done, that's a matter of debate.
ये एक्यूज जो है, अगर विदाउट एविडेंस एक्यूज है तो मैजिस्ट्रेट प्रोसीजर के अंदर का कंपनसेशन प्राप्त कर सकता है.
See, basically you must remember one thing, that firstly there should be a statute. Now we have provisions under CRPC where compensation can be granted to victim. So if the trial judges want to do it, they must be supported by law. If there is a law, provision of law which enables them to grant compensation, they will be able to grant. And as I said, in a given case, the remedy of approaching constitutional courts is always available for wrongful detention, for wrongful prosecution or malicious prosecution, that is always available. And therefore, in our system also, suit can be filed for compensation on account of malicious prosecution. So the problem today is, if a session judge decides to grant compensation to an accused, there is no provision under law. And a session judge can't exercise powers under Article 226. So these are the limitations.
Thank you.
Section 359. Now it is in new Bharatiya Suraksha BNSS, जिसमें ये है कि यदि मुलजिम को अनावश्यक रूप से गिरफ्तार किया गया है तो it can be compensated. Yes.
No, but actually I wanted to give example. But 350, that section operates in very, very limited category. Very limited category. Because only if those criteria are fulfilled, then court has power. But if you see the criteria laid down in that section, in very, very rare cases it can be invoked. Maybe under new CRPC they could have enlarged the scope. They have not done it.
Noxious liability का suit ही file कर सकते.
Malicious prosecution, compensation, suit for compensation, even somebody can approach rejurisdiction violation of Article 21. There are remedies available. Person is not without remedy.
Lordship, I am AP Mishra, Principal District Session Judge Devash. Sir, in Madhya Pradesh, for the disposal of old cases, the scheme was 25 old cases, dead cases, in which 100 cases were decided in the year. Now this scheme has been merged in
Guidelines
scheme
taken by Supreme Court.
guided by Hon'ble Supreme Court. in this scheme, 25 old civil cases and 25 old criminal cases are to be decided, and 20 execution cases. Firstly, it was directed that cases over 20 years be decided in this scheme. If there is no cases in this category, means cases more than 25 years, then all cases which are pending in this case, the court be decided. In the district like Devas, only 52 cases are pending more than 20 years, more than 10 years. Only 2 cases is pending, which is more than 20 years.
So what is your question?
सर मैं सर ये मैं कहना चाहता हूँ कि सर कुछ केसेस, कुछ कोर्ट ऐसी हैं जिनमें अभी दिसंबर में जो चालान फाइल हुए हैं सर, दिसंबर में जो केसेज आए हैं उनको डिसाइड करना पड़ा उस स्कीम के अंतर्गत। तो एडवोकेट थोड़ी एग्रेसिव हैं कि सर मतलब इस स्कीम को न लेकर के थोड़ी बहुत जल्दीबाजी हो रही है। तो देन सर इसमें कुछ ऐसा होना चाहिए कि जिन कोर्ट में केसेस कम हैं या बिल्कुल नए हैं, वहाँ थोड़ा सा सर मतलब थोड़े एडवोकेट एग्रेसिव हो रहे हैं कि सर जो है मतलब इसमें जल्दी जल्दी हो रहा है कार्रवाई, रिलैक्सेशन थोड़ा सा।
And one more thing, basically we have left it to High Courts to modify that also.
Sir.
And secondly, please remember one thing, no advocate has vested right to delay the trial.
Sir.
Ultimately, as judges, as Chief Justice has rightly said, ultimately you have to talk to the members of the bar.
Okay.
And you should impress upon members of the bar in your district that it will become ideal district in India if you are in this position that cases are being heard immediately. And in fact, we are examining that sitting in Supreme Court. So I'll call for the record of this district. If it is ideal district in terms of disposal of old cases, we can publish that also. In fact, you should every PDJ should aspire to do that.
Thank you, sir.
Right.
But that's all.
We can close now.
Yes, please.
Yes,
That's all.
thank you, my lord. It is now time to honor our guests and express our gratitude for sparing their valuable time. In this respect, I now request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, and Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, to present our chief guest, my lord, Honorable Shri Justice Abhay S. Oak, Judge Supreme Court of India, a memento which is a painting depicting the famous Gond art unique to the state of Madhya Pradesh. Thank you, sir. I now request respected Director, sir, and Registrar General, sir, to felicitate my Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice, by presenting a painting as a token of our gratitude. Thank you, sir. I now request respected Director, sir, and Registrar General, sir, to felicitate my Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Judge, High Court of Madhya Pradesh, by presenting a painting as a token of our gratitude. Thank you, sir. I now request Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, to deliver the vote of thanks.
My Lord Shri Justice Abhay S. Oak, Honorable Judge Supreme Court of India, My Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice High Court of Madhya Pradesh, My Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Chairman Governing Council MP State Judicial Academy, Honorable Judge High Court of Madhya Pradesh, Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy and Officer of the Academy, Shri Pradeep Mittal, Member Secretary MP State Legal Services Authority and Officer of MP SLSA, Officer of the Registry, participant, Judicial Officer from the District Court across the state, viewers who have joined us virtually, ladies and gentlemen, a very good afternoon to everyone. As we draw this inaugural session to close, it's my honor to tender the vote of thanks. On this occasion, first and foremost, I would like to extend my heartfelt gratitude to Honorable Shri Justice Abhay S. Oak, Judge Supreme Court of India, for honoring us with the kind presence. Your esteemed presence has been crowning glory of our conference motivating us to pursue justice with unrelenting dedication and excellence. Your pulse of wisdom and guiding hands have been lighthouse in our journey, illuminating the path forward. We extend our heartfelt gratitude to your Honorable for the time and effort so magnanimously dedicated to imparting your invaluable knowledge. Your actions have eloquently demonstrated that true leadership is measured not by words but meaningful deeds. Thank you, Lordship. I express my gratitude to Honorable Shri Justice Suresh Kumar Kaid, Chief Justice, High Court of Madhya Pradesh, for blessing and guiding us with the inspiring words. As the head of judiciary in our state, your leadership and vision have been instrumental in the shaping this judiciary into a beacon of hope for the common man. Your commitment to justice and your tireless efforts to uphold the Constitution have been a source of inspiration for us all. Your Lordship kindness and magnanimity were evident from the very first day as your Lordship took care of the judicial officers with the fatherly demeanor. This was exemplified by the thoughtful resolution of the matter involving a married couple who, despite living apart, were given due consideration. Your Lordship patiently listened to both the officers and the common people, reflecting your commitment to the justice and compassion. We consider ourselves truly fortunate to have such an exemplary Chief Justice. Thank you, Lordship. My heartfelt, sincere thanks to Honorable Sri Justice Sushrat Arman Karkei for investing the precious time in the conference. Your Lordship has really taken keen interest to guide throughout. Your inspiration means a lot to us. Your Lordship's visionary leadership and steadfast support has been cornerstone of this conference success. As the esteemed Executive Chairman of the MP State Judicial Academy, your Lordship has demonstrated unparalleled commitment to the advancing judicial education and training. Your ability to lead with wisdom, integrity and foresight has set a benchmark for others to emulate. Your dedication to elevating the standard of justice in our state commands the highest admiration and respect. Thank you, Lordship. I also extend my sincere thanks to Honorable Judges, High Court of Madhya Pradesh for sparing their valuable time and gracing these occasions. Thank you, Lordship. I also extend thanks to Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, Officer of the Academy, Officer of the Registry for their painstaking efforts in organizing this conference. I also extend thanks to all the judicial officers across the state, especially Jabalpur, for their continuous support. My gratitude to the IT team and staff, High Court and Academy, whose hard work and dedication made this event possible. Your meticulous planning and efforts behind the scene ensured everything runs smoothly. On the personal note, with the kind blessing of His Lordship, I will be there along with all the judicial officers present today in the morning session of the tomorrow to discuss issues relating to the district judiciary, establishment and administration. Please feel free in raising concern relating to the subject. I would be happy to be assistant in addressing the grievances. Thank you, Lordship.
Thank you very much, sir. With this, we have come to the end of the inaugural session. I invite all the dignitaries and esteemed participants for a group photograph to take place in the front lawn of the Academy, which will be followed by lunch. We shall begin the second session at 3 p.m. Thank you. Namaste.